I don't care that you have kids. I don't care that you got a billy goat and that you need to contact her to do it. Okay, go for it.
Starting with the one from February 17th. Well, that was filed on February 17th. So February 14th offense. On February 14th, officer was dispatched to a threat to life at a business in Houston, Harris County at 8:51 in the morning. The reportee stated that on the call slip, her ex-boyfriend, the defendant, was on his way and was threatening to blow the place up. Upon arrival, officer found the reportee was not on scene when the threat was made. Officer observed the doors to be locked and complaining witnesses hiding inside behind the desk. Complaining witness one stated she received a phone call at the business from the defendant who stated, "Y'all better close that clinic because I'm on my way to blow it up."
How do they know it's him?
Complainant one had the phone on speaker. Complainant two recognized the voice and asked who this is. Defendant stated who his name of Jonathan Castellanos. Defendant stated to complainant witness two that you're going to be the first to go. Complainant witness two stated the defendant had visited the business multiple times due to a previous relationship with the owner, the reportee.
Okay, I think we're good. I'm gonna go blow this place up.
Correct, Judge. It doesn't rise to a reasonable imminent fear. He was on the phone. He wasn't even at the location.
He doesn't have to be there. But imagine how many.
And identity as well. They allegedly said that he says, "Oh, this is Jonathan Castellanos."
He's been there before. They recognize a person. They recognize his voice. If you call me, I know. If Victoria calls me, I'm going to recognize her voice. She doesn't have to tell me who she is, but I'm going to recognize it. I think there's enough on that one.
Okay.
We'll go on the next one.
Sure. Yes, sir.
Okay.
The next one on June 17th, 2025, officer dispatched to 7705 Wright Drive, Harris County. The complaining witness on scene told the defendant to leave the location. Defendant refused to do so. Defendant threatened to return with a gun and then kill the complaining witness. Complaining witness had video footage of the interaction.
Okay, so say that one again.
So, officers dispatched to an address.
Okay.
Complainant told the defendant to leave the address and the location. Defendant refused to do so and threatened to return with a gun to kill the complainant. The complainant had it on video.
Again, he said that he would return to the scene and allegedly shoot him. There's no statement of that there was a gun on him or that he was making any gestures that would indicate that he was going to shoot. He said he would come back. That's a future threat. That's why I don't believe it rises to a reasonable fear of imminent bodily injury.
Is this the same place?
No, sir.
This is a different place?
This one is actually a residence where the defendant came to the property, was there. And then,
What do you think, or to her response? Sean?
as far as probable cause goes for the DIMS, the imminence of him saying, "I'm gonna come back and shoot you."
No, he said, I would come back.
Determine the gun.
Does would indicate imminency? I will come back and I'm gonna kick your butt. I would.
Right.
Is would conditional? Is it imminent? Is it enough, or was it enough of a statement to put the person in fear? And how do you quantify that? How do you show me that the person was in fear, so to speak?
Right.
What do you have?
So, just from the DIMS, Judge, the complainant had footage of the defendant on property making threats and trying to break into one of the shops in the property. And then was asked to leave, and that's where.
Well, now you're adding new facts to it. You're saying he's
understand.
trying to break in.
So that's just, I went straight to the threat. This is,
No, but you know, in these types of cases, a lot of times there are other collateral things that happen that can help, so to speak, because other facts can indicate an intent to come back. So is he, what time of day or night was this? Is he really trying to break in? Is this the middle of the night he's breaking in? Is it during the day?
didn't say the time of day, Judge. That's.
Okay.
Actually.
How do you know he's trying to break in?
The complainant had video of the defendant on property making threats and trying to break into one of the shops on the property. Got the name of the defendant from a tenant who had done business with the defendant in the past. The video footage showed license plate of the vehicle the defendant was driving.
So there's issues in the past with these people?
On the, sounds like the other businesses in this location, one of the other tenants over there told the complainant that they recognized the defendant. So I understand that there's still the wood come back and shoot you, but I would argue that if someone is trying to break windows and get into a place and then when asked to leave, so that he's going to break back with a gun, that would put me in fear for my life. So
Would a reasonable person be in fear in that instance?
No, Judge, I do not believe a reasonable person.
If someone's breaking into your house,
Well, they don't even, the DENS doesn't even state what actions that they saw that made them feel like that the defendant was breaking into the property. All it says is the defendant on property making the threats and trying to break into one of the shops on the property. It doesn't indicate what specific shop, and also it doesn't tell you what actions. He could be looking inside of the windows and they could just assume that he's breaking in. We don't know. The DENS does not state.
yeah, no, I think that it's enough. I mean, it's such a low standard for probable cause. We have someone who's allegedly trying to break in. You know, they tell him to go away and then I'm gonna come up or I'm gonna, I think that a reasonable person would be in fear. I would.
Not of imminent, serious bodily injury. He's making a future threat stating, I would, and that's conditional. I would come back and I would come back with a gun and kill the complainant. That's a future threat. It's not saying that he had any weapons on him that can, you know, give rise to fear. And then as far as breaking in, it says one of the shops. Is it the shop that the complaining witness was in or not?
What, give me the statement again.
yes, Judge. So the complainant advised the defendant, let me show this the right one, sorry, I actually scrolled up. This is, complainant advised the defendant who knows about the site, refusing to believe. Yeah, refusing to believe when he was asked to do so. Defendant made threats toward the complainant, stated he would return with a gun and kill the complainant. Complainant had a video showing the defendant on property making the threats and trying to break into one of the shops on the property. Complainant acquired the name of the defendant from a tenant who had done business with the defendant in the past. And then it goes into license.
Yeah, all right. I'll find no PC on that one, but I'm gonna find probable cause in the other one.
Thank you, Judge.
Okay. Mr. Anderson, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case. There's a protective order that has been issued and you need to get to know it. If you do something to violate this protective order, they will file additional charges against you, a violation of a protective order, and that is one of the worst misdemeanors that you can pick up. Do you understand? You're not to have any contact with this person whatsoever. I don't care if she calls you. If she calls you, hang up. If she texts you, do not reply. If she comes to your house, don't answer the door. You're the one that's going to go to jail, and this is not a revolving door. You will not get PR bond after PR bond. Do you understand? How old are you, sir? How do you support yourself? Okay. It is time for you to get a job. Job. I am now making that a condition. You don't get to just sit at home and do nothing all day while everybody else is paying for you. You need to get a job, to do something with your time, because otherwise life tends to get self-destructive. You hang out with the wrong people, you pick up new cases. You are now 19 and on number 1, 2, 3. No more. Do you understand? So appoint a lawyer, please, and then back in 2 weeks for a job.
Yes.
When you come back in 2 weeks, I want to see 20 to 30 applications filled out, and I want proof, not spoken word. Do you understand me? If you haven't done anything, it's not going to go well between us. No probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
So judges for the
Let's do both.
Okay.
Dealer's choice.
So the unlawful judge coming from the days on November 6th, 2025, officers dispatched a disturbance on a weapon call. In Harris County, officer arrived on scene and met with complainant. The defendant was on scene at arrival. Complainant advised that she and the defendant were in a dating relationship for 3 years. Said the defendant saw her playing a game app on her phone and he thought that she was cheating on him. Complainant said the defendant and her got into a verbal argument. The defendant shoved her into their bedroom, closed and locked the door. The defendant placed the chair in front of the bedroom door and he sat down on it. Sat there so that she would not come out. Complainant said that whenever she would get close to the door, the defendant would get up and intimidate her to go back in the bedroom. Complainant was scared and nervous that she never used the restroom and was released the next day. Complainant said the defendant gave her food, but she was scared. Defendant was eventually released from the bedroom. Complainant said the defendant gave her back her cell phone. And then a notification went off. And the defendant got agitated and demanded the phone back. Complainant refused. Defendant grabbed the phone and by her chin and the top of her head. She thought it was going to break her neck. Complainant dropped her phone. Defendant snatched her phone. Valued at $1,200 along with her other electronic belongings, iPad, smartwatch, and left before the police arrived. That's
The assault, is that this or is this is it another
that is a
case?
separate case, Judge.
Different
Same
defendants?
complaining witness.
Same complaining witness?
Yes,
Okay.
Judge. The assault is on an officer conducted a follow-up investigation. The complainant advised that the defendant, her ex-boyfriend, and her on December 24th in Harris County went to HD on Shepherd. The defendant was driving and their kids were in the car. The defendant received a call from a bondsman from a previous case the defendant had. The complainant was facing the window of the car when the defendant then struck her 2 times in the left temple, causing pain. The complainant was transported to LBJ Hospital for head injuries upon arrival at PHEB.
Okay. Do you see anything else that's open? Can you run an NCIC?
I can read that.
Please.
That's already.
I'm not seeing anything else on the judge.
Okay. Veronica, can I get a PSR on Mr. Addison, please? So what do you think about bond, guys? What's appropriate?
I'm asking for 2,500 at each, Your Honor. My client is 40 years of age. He does have 3 children that he supports, ages 19, 15, and 11. They all live with him. He does own his own business. He escorts 18-wheelers for a living. He goes interstate to do his work. Generally, he works 5 days a week. He's a lifelong resident of Houston, Texas.
Who do you think? 2,500 on both.
Yeah. Okay with that, Judge.
Okay. I'll give you what you're asking for. You're asking, and I'll set both of your bonds at $2,500. I want you to understand something, Mr. Addison. I'm going to protect my community at all costs. I don't care who you are. I don't care what color you are. I don't care how old you are. If I have to set your bond at $2 million, I will do it in a heartbeat. I've done it before, and I'm not going to lose any sleep over it. As a condition of your bond, you're ordered not to have any contact with this complaining witness at all. I don't care that you have kids. I don't care that you got a billy goat and that you need to contact her to do it. You have contact, and any contact with this person, I'm going to put your butt in jail. I will revoke these bonds and I'm going to set them high. I'm issuing a protective order on both of these cases that identifies Miss Johnson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat, harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. This includes the address on Annabelle. Do you understand? Any contact whatsoever, and I don't care how minute it is, you will go to jail. You're in violation, and it's very possible they file a violation of a protective order. That is one of the worst misdemeanor cases you can pick up. Do you understand? Do you mind reaching out to the complaining witness to let her know what we've ordered? No contact. He's not allowed to go to where she works, where she lives, no weapons. So that if he attempts anything, you guys let us know and we'll take the appropriate action.
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Holt. If he tells me he cannot get a hold of you, I'm going to revoke your bond. There's not a revolving door. You will not get any more PR bonds. Do you understand? If you pick up a new case, if you violate these conditions, it's just not going to go well for you. I'm, Mr. Addison, not asking for much. I want my streets safe, and I'm going to do everything in my power to protect them. You understand me? So for now.
Sometimes the courtroom hands you a case that almost defies belief. A man calls his ex-girlfriend's workplace. He threatens to blow the entire clinic up. And when the person on the other end asks who it is, he says his own name, on speakerphone, with witnesses listening. Judge Fleischer's response was exactly what you would expect. Short, dry, and devastating. I think we're good. But what followed was something more complex. The defense attorney stood up and made a genuine legal argument that threatening to return with a gun sometime in the future is not the same as placing someone in immediate fear, that the law requires imminency, and the judge, to his credit, took that argument seriously, engaging in a back-and-forth debate about what a reasonable person would feel in that moment, whether trying to break into a shop at the same time a threat is made crosses the line, and where probable cause actually begins and ends. On the second charge, the judge agreed with the defense. No probable cause. It is easy to see a courtroom and think the outcome is always obvious. This case is a reminder that the law is precise, that standards matter, and that even bizarre cases require real analysis. What is less ambiguous is what we saw in the Addison case later that same morning. A man who locked a woman in a bedroom through the night, grabbed her by the face hard enough that she feared for her life, and stole her belongings before disappearing. The judge's response there was unwavering. No doubt, no debate, that community will be protected. Two different cases, two different legal standards. In one judge trying to get it right in both. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.